Please take note, students are only allowed to underline the sections of the Act in the textbook with pencil, and the slides in this recording include snippets from the Act. These snippets have been coded in the manners described below in order to enhance students' understanding to what is important and for ease of reading. Section 57 states that the shareholder is defined as any person entitled to exercise any voting rights, irrespective of the form, title, and nature. And this is for the interpretation of the governance of companies and therefore applicable to sections 60 to 62 and 64 to 78 that will be discussed now. This section states that a resolution that should be voted on at the shareholders' meeting may instead be submitted to shareholders for consideration and be voted on in writing by the shareholders. Students should take note of the requirements of such a resolution. The board may call a shareholders' meeting at any time, but must hold a shareholders' meeting if shareholder decision is required by the Act or the MOI, to fill a vacancy on the board, when otherwise required by the MOI, or when the annual general meeting of a public company is required. A public company must have an AGM, no more than 18 months after the date of incorporation and once every calendar year, but no more than 15 months after the date of the previous AGM. The AGM has specific items to be discussed, as listed in the Act and highlighted in orange. A public company or a non-profit company must deliver notice within a specific time frame to each shareholder of each shareholders' meeting in a prescribed manner and form. A shareholders' meeting may not begin until sufficient persons with at least 25% of all voting rights are present, and a matter to be decided on at such a meeting may not be considered unless sufficient persons with at least 25% of all voting rights are present. If a company has more than 2 shareholders, a meeting may not begin or a matter may not be discussed until at least 3 persons are present and the vote's quorum is satisfied. Every resolution of shareholders is either an ordinary or special resolution. An ordinary resolution requires 50% of the voting rights, and a special resolution requires 75% of the voting rights. The board may propose any resolution to be considered by shareholders. Any 2 shareholders of a company may propose a resolution concerning any matter in which they are entitled to exercise voting rights. This matter must be considered at a meeting demanded by shareholders, or at the next shareholders' meeting, or by written vote. The business and affairs of a company must be managed by a board of directors, who must have authority to exercise their powers and perform a company's function to the extent that the MOI provides. A private company must at least have 1 director, and public company or non-profit company must at least have 3 directors. The incorporator of a company is the first director and will serve until sufficient other directors have been appointed. Each director must be elected by persons entitled to exercise voting rights in the appointment of directors, and each director must serve for an indefinite term or term as set out by the MOI, and must be voted on separately as an individual candidate. A person may be ineligible or disqualified to be a director of the company. Refer to sections 69.7 and 69.8 for specific conditions. Despite anything to the contrary of the MOI, a director may be removed by an ordinary resolution at the shareholders' meeting by the persons entitled to exercise voting rights in the election of a director. Before removal, a director must be given notice of the meeting and the resolution, and also be afforded a reasonable opportunity to make a presentation to the meeting before the voting takes place. If allegations by shareholders or fellow directors are made that the director has become ineligible or disqualified, or incapacitated or negligent to the extent that the director is unable to perform the functions of a director, the board may remove such a director by resolution. The board may appoint any number of committees or directors and delegate any authority of board to any committee. Such committee may include persons who are not directors, may consult with or receive advice from other persons, and has the full authority of the board in respect of the matter referred to it. In terms of Company Regulations 43, a Social and Ethics Committee must be appointed by listed companies, SOCs and other companies that has scored above 500 public interest score points in any 2 of the previous 5 years. Within Section 72(8), there are certain aspects a Social and Ethics Committee is entitled to. A director authorized by the board may call a meeting of the board at any time. He must call a meeting if required to do so by at least 25% of the directors in a case of a company that has at least 12 directors, and 2 directors in any other case. A resolution that can be voted on at a meeting can be adopted by written consent or electronic communication, provided that each director has received notice of the matter to be voted on. Common law states that all contracts between a director and the company are voidable at the option of the company, as common law applies the principle that there should be no conflict of interest between a director and the company. This is because a director is required to look after the best interests of the company instead of his own interest. Section 75 is a statutory agreement that presents a means of accommodating this common law principle, but does not replace it. If a director or person related to the director has a financial interest, this matter must be considered at a meeting of the board, where the director is required to do the following. He must disclose the interest and its general nature before the matter is considered at the board meeting. For example, if the board is entering into a contract which the director has 15% shareholding in that company, the director should disclose such an interest. Secondly, the director must disclose to the meeting any material information the director has relating to the matter. For example, the director may be aware that the company with which the board is considering into an agreement is in financial difficulty, a fact that might not be known to the fellow directors. The director may, if requested, disclose any observations or insights, for example, his opinion on the extent of the financial difficulties. The director must not take part in the further consideration of the matter and must leave the meeting. The director, however, remains part of the quorum but cannot vote on the matter. A contract in which he has financial interest will be valid if approved after full disclosure of the matter by the director, or if the contract was approved without the necessary disclosure. The contract would be valid if it has been subsequently ratified by a shareholder resolution, or if declared valid by a court. A director should not use his position to gain an advantage or knowingly cause harm to the company. A director must communicate to the board any information that comes to a director's attention unless this information is immaterial to the company, is generally available to the public, or is bound by a confidentiality obligation not to disclose information. A director must then exercise his powers and perform the functions of a director in good faith, within the best interests of the company, with a degree of care, skill, and diligence that may be reasonably expected of a director. Students must take note, this section would apply to many instances where the actions of directors are in contradiction with laws and regulations. Section 77 indicates when a director may be liable. A director may be liable for a breach of fiduciary duty where a director has failed to disclose a personal interest, as described in Section 75, use this position to gain an advantage for himself or harm the company, as described in Section 76, failing to act in good faith or not considering the best interests of the company. A director may be held further liable for any breach of a provision of the Act or MOI, or if he failed to act with a degree of care, skill and diligence. A director may be liable to a company for any loss or damage arising from the following acts. If he continues to act for the company, knowing that he lacked authority, carrying on business knowing it was reckless, being a party to an act or omission despite knowing that it had a fraudulent purpose, having signed or consented to publication of a document or financial statements despite knowing it was false, misleading or not true, be present at a meeting and failed to vote against something that was in contravention with the Act. Students should take note of these specific matters. Students must also take note that this section would apply to many instances where the actions of directors are in contradiction to the Act.